The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children, and therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think which arise for consideration before this honorable court when these kind of petitions are filed. I'm sorry to say this, and let me try and perhaps tone down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. The cause is different from the case. And it is important for the court to seriously consider one aspect here. When there are issues of legislative competence, there's another figure, so to speak, which is involved. And that figure's powers come under Article 111 of the Constitution, which is to say that if a legislative proposal ultimately meets with the consent of both the houses, ultimately it has to go to the Honorable President. And the Honorable President also has the power to recommend amendments to a legislation. Therefore, this is not just a question of legislative prerogative or legislative sovereignty, either from an external or an internal perspective, but there are multiple dramatis personae and stakeholders of this particular equation, the society being the chief. Because ultimately, the petitions raise the question of changing the paradigm with respect to heteronormative attitudes of legislations in general. It is not just about the SMA. Plus, my lords, is not dealing with the religion-specific legislation here, it is the SMA, which means all the more the society's participation when it comes to the SMA is warranted, is mandated, is compulsory. Because at least if it were to be with respect to certain, let's say, religion-specific legislations, it can be said that there is an identifiable group which has a locus to argue here. But when it comes to the SMA, it can't be the argument that only those who subscribe to the values of SMA are allowed to participate in these proceedings. Secondly, as has been already submitted, Section 21 of the SMA has a direct bearing on personal laws. So even with respect to SMA, the society has a right to participate. The reason why the additional written submissions become relevant is because I filed an annexure, which is the Manual for Parliamentary Procedure of 2019, which was published by the Ministry of Parliamentary Affairs. And that particular manual, so to speak, has Chapter 9, which deals with the business of legislation. Close to 30 clauses exist detailing the manner in which a legislative proposal is to be considered in the first place, how the ball is set rolling. And in that, if I may just refer to my additional written submission here, I'll walk my lords through the relevant portion here.